Hello, I'm Joanne Law. Welcome to this short presentation about roles in the family law system. This is an overview of some of the information I'll cover. When we're looking at roles, there are really quite a diversity of roles within the system. And here are some of them and examples. With family dispute resolution practitioners, the current role was established under the Family Dispute Resolution Practitioners Regulations in 2000. And there are a few provisions that are really important. We need to be independent of all the parties involved in the process. We are responsible for assisting people affected or likely to be affected by separation or divorce to resolve some or all of their disputes with each other, or help them if they're seeking to apply for a parenting order under Section 65C to resolve some or all of their disputes relating to the care of children. So one of the major misunderstandings in the system is that family dispute resolution is only for parenting matters. That's not true. It's for all matters affecting separation or divorce, which includes financial and property settlement negotiations. There's also some misunderstandings where former judges or barristers or accredited mediators who are not qualified as family dispute resolution practitioners provide services as family law mediators. Do need to recognise that nationally accredited mediators receive a very short training compared to family dispute resolution practitioners, and generally it wouldn't include any training about family law and very limited training about family violence. As Mediation Institute, we love our nationally accredited mediators, but we're strongly in support of family dispute resolution practitioners doing family law mediation. There are two family court systems in Australia: the Federal Circuit and Family Court of Australia, which was formed in 2021 when then two separate family courts were merged. And the purpose of that was attempting to streamline the family court. The Family Court of WA also operates independently. However, it is very closely aligned to the Family Law Act of 1975, but it does have the Family Court Act of 1997. Over the last few years, there's been efforts to harmonise. There used to be some significant differences for de facto couples, but those have changed since then. With the family court, there's very useful information available, including the central practice direction, which I'd encourage family dispute resolution practitioners to be aware of. The family court's made up of judges, registrars, and the dispute resolution services. A lot of the work is done by registrars and judicial registrars, and they have a variety of functions, from facilitative, evaluative and determinative. They run the initial hearings, review applications for consent orders, run conciliation and dispute resolution conferences. And this role was greatly expanded with the merger of the courts and the forming of the Federal Circuit and Family Court of Australia 2021. A lot less cases than previously actually go to final judgment, and those tend to be the cases where all of the efforts of the registrars and the judicial registrars haven't been successful in helping the participants reach agreement. Many of the cases in the family court are ordered to dispute resolution processes, either within or external family dispute resolution. Some of those, certainly the ones in the court, tend to be conciliation, which is a more evaluative process, but the registrar acting as a conciliator doesn't have the power to order the outcome. They certainly will provide advice and suggestions, but don't have the power to determine in that. There is a function of family law arbitration in Australia for property matters. But it's an option for people to attempt an arbitration award. Is registered with the court, so it is binding, and it's like a private judge. So they consider evidence and cases put by either side and make a determination. With the children's court services, that's been greatly expanded as well, and the purpose of that is to try and collect evidence about the best interests of the child and provide reports to the judicial officers. There's a statutory appointment as a family consultant, and also authorisation as family counsellors. So the family consultants, they do assessments, prepare reports ordered by the court. They all meet with the parents and the children and work closely with the court, providing reports and recommendations. They are mandatory reporters, and the conversations with them are not confidential, so they'll include whatever they feel is appropriate in the reports. Family counsellors, they may participate in court-ordered dispute resolution and triage interviews under the Lighthouse model with regards to family violence, and their work is confidential and inadmissible, so it can't be used as evidence. These professionals generally will have psychology or related qualifications, and the same person can be a family consultant and a family counsellor, but they wouldn't be for the same case. There are some other roles. Regulation 7 family consultants, they conduct child and family assessments in court reports, including child impact reports, which are generally ordered early in the proceedings if there's concerns raised, and family reports, which are generally ordered later in the case when it's getting towards final hearing stage. And these consultants are generally private practitioners who are paid either by the court or the parties for these reports, which can be quite expensive. The role is defined in Part 3 of the Family Law Act, and generally, again, it's not confidential, and the reports they make are inadmissible, but there's certain protections that are provided around them about who can access them. There is currently a bill that's just passed Parliament that will provide greater regulation for this role. Child contact services. So these services provide supervised contact between parents and their children where there are safety concerns. Sometimes it's less about safety and more about the fact that there's been a long period of time between contact, and so that can assist. Supervised changeovers where there's not considered to be risk of harm to the children, but there's a high level of conflict between the parents, which is going to risk exposing the child to family violence. So one parent drops off the child, leaves, the other parent arrives and picks up the child. Child contact services are not confidential, and evidence about how the contact proceeding can be requested by the court as evidence. At the moment, there's not a lot of regulation about the services. The Law Council of Australia, it's a national representative body for lawyers and legal professionals and societies that provides advocacy to the government and advises the government, courts and federal agencies. It acts on behalf of lawyers and barristers. Legal practitioners, so they're made up of a number of different roles. So barristers who act as advocates for their clients or advisors, they're usually briefed by a lawyer or solicitor. There's also independent children's lawyers who are appointed by the court to represent the interests of children. Collaborative law, you may have heard about. It's an approach where lawyers contract out of representing clients in family court. The intention is that they don't have a vested interest in the negotiations failing, leading to a more financially rewarding for the lawyer court action. There are some other distinctions in the model. It can be a more expensive approach than family dispute resolution, but where there's a high level of complexity, it can be a really good approach. Legal advisors, they're critical to the family law system, providing clients with independent legal advice and assistance with court applications and representation. It's important as a family dispute resolution practitioner that you know how to assist clients to access independent legal advice. Independent children's lawyers, they're appointed by the court to be an advocate for children and often through legal aid. There's some triggers that would indicate to the court the need for an ICL to be appointed, and there's a list there. Their role is to represent the child's best interest, which isn't always the child's view. and there's now a requirement that they meet with the children unless there's a valid reason not to. So there's some really extraordinary practitioners working as independent children's lawyers, and the changes in regulation are seeking to strengthen that. There's a term, prescribed child welfare authority, that you'll come across. These are the state-based bodies established under the child welfare laws to support the protection of children against abuse and neglect, and they receive mandatory reports. Their role is to investigate these allegations of child abuse or neglect, and they have a number of powers. They can remove children from their homes, they can take on parental responsibility, remove it from the parents, either through the children's court or the family court, care and protection orders, out-of-home care, all those sorts of things are organised by the Prescribed Child Welfare Authority and the officers who work for it. There's been amendments to try and improve information flow regarding at-risk children. With a large system like the family law system, there's always the challenge of silos and information gaps. There's work being done to try and improve that situation. There's some general resources available for families and some directories, generally flowing through to the government-funded services. But you'll be able to use this resource to find information about counselling, legal advice, financial advice, FDR services, information and help, which you will need in some of your assignment tasks. Family Relationship Centres, FRCs, they're generally run by not-for-profit organisations and Relationships Australia. These are provided with funding by the federal government to provide these services, and they include counselling, family dispute resolution, post-separation parenting programs, behaviour change programs. They often have programs for teenagers and children and parents going through separation and divorce. They'll also have funding to run the Family Law Pathways networks in your area. So I think it would be really good for you to find out what's happening in terms of the Family Law Pathways and try and connect in. So independent professionals, a large number of the people that work within the sector are independent professionals. For example, family dispute resolution practitioners who are regulated fully, some are completely unregulated. So it's really important to make sure that you're looking behind flashy websites or other things to see what credentials people have to provide services. Some of the therapeutic services are eligible for Medicare rebates, and they can be referred to get that funding by their GP, their client's doctors. There is no financial support in Australia from the government for private family dispute resolution services. Just a note regarding some of the inadmissibility, it's generally only if it's a regulated professional that's providing the services. There's a wide variety of roles within the family law system, with new roles appearing as they are needed and identified, often then not covered by any legislation or regulation. So it's important to be careful about what and why people are providing services, but that's not to say that there aren't some excellent support services out there. It's an expectation that as family dispute resolution practitioners, we work collaboratively in terms of referring clients to services that can assist them with needs not able to be met by us as family dispute resolution practitioners. We'll talk about conflict of interest further in the course, but you definitely wouldn't be able to provide, for example, family dispute resolution and individual counselling with a client. So thank you. Hopefully that's informative for those of you that are new to the system.